also to welcome very warmly Professor Leah Wortham from Columbus School of Law, also a friend of ours for a long time, and Professor Tim Waters from our School of Law, whom we have the chance to meet here personally a few months ago and discuss also the issues connected with the war in Ukraine. But with us will be also Professor Iryna Zavrukha. I hope I pronounced it, Zavrukha. I hope I pronounced the name correctly, from Southwestern Law School, and Professor Geoff Watson from Columbus School of Law will join us in few minutes, also to share with us his comments and opinions on this very controversial and complicated issue. What we'll discuss, of course, first we would like to ask our panelists and guests to present their opinion. I hope then in the discussion we try to guide it and perhaps to pay a special attention to these topics, to these issues. So first of all, the Ukrainian vision of this court, of this special tribunal, and then if it is a real idea that should be discussed, then we should pay much more attention about the personal jurisdiction and creation of this. What will be the base of the possible base of that agreement, resolution, international agreement. Then the crimes charged, so the subject matter jurisdiction, who could we see as the prosecutor, who could we see the judges, the qualification, appointment. Then perhaps if we would have time enough, we should think about the trial itself and execution of possible sentence. There is another open problem. I don't think that we will have time enough just to jump into it. It is the cooperation with the ICC and the relation between this possible international tribunal and the ICC. Of course, in all these matters and issues we will discuss, we'll think about the benefits and risks and obstacles that are connected with the whole idea that was already discussed last time when we met with Professor Ambos from Germany, and we're talking about how complicated the question is. So let me spare time. I hope that we will manage this meeting with Olena Sharban, who's also the person who inspired us to organize the next panel on this issue. So I ask you, Olena, as well, just to help me with managing the whole discussion and the whole seminary. So as a first, I would like to ask Ambassador Korynevych just to present this general idea of this international court from the point of view of Ukraine, telling the truth, or Ukraine officials. Take the floor, please.
Yeah, dear colleagues, good evening from Kyiv. It's a big pleasure and honor to be present today here with you. Of course, the fame of Jagiellonian University and its role and legacy and heritage is very well known here in Ukraine and Kyiv. And I myself am a colleague of yours because I also teach at Taras Shevchenko National University of Kyiv, the courses of international humanitarian and international criminal law, so courses of public international law sphere. So it's a pleasure to discuss these issues today with you. And of course, it's a pleasure to have such a common friend as His Excellency Judge Mykola Hnatowski, who is, of course, my personal friend and the best Ukrainian international lawyer, I believe, these times. So speaking about the Special Tribunal for the crime of aggression against Ukrainians, this idea, I think that, and it is seen also from your seminars, from the things which we heard just right now from Professor Rubel, that this issue is high on the agenda. And this issue is high on the agenda, and I think that the common idea, which I quite often hear from people, is that while somebody considered in March 2022 that this is totally impossible, in November, December 2022, a study to say that well, in general, it is possible, it is doable. So I think that what we already reached, of course, it's not a result. It's just the another step on this way forward, is that the idea that the crime of aggression against Ukraine must not go unpunished is there. So I think that this is already a very important issue, which brings to the arena the discussion of how this accountability for the crime of aggression may happen. For Ukrainian international lawyers and for Ukrainian governmental lawyers, it is quite obvious that if the crime of aggression is not prosecuted, is not investigated in this particular situation, in the situation of Russian aggression against Ukraine, when we do have all the recognitions of the aggression itself, including by the overwhelming votes by the UN General Assembly resolutions, if it is not done now, it will not be done ever more in future. So I think that this is also the decisive moment for international lawyers to see how do we move forward with the crime of aggression. And since I heard also that great professors participated here in your seminars, in particular from Germany, I think that also some other view from Germany, for instance, by other international lawyers who are a bit more supportive to the idea to solve the special tribunal, can be sounded. In particular, yesterday in Frankfurter Allgemeine Zeitung, was published a great essay by 3 international lawyers from Germany on this matter. So for us, for Ukraine, the establishment of the special tribunal is one of the priorities. It comes directly as instruction from President Volodymyr Zelensky. As you know, President does have, and he introduced a peace formula, which includes 10 elements, 10 points. And one of that elements is justice and accountability. And inside that justice and accountability element, there is the issue of special tribunal for the crime of aggression. The work on the establishment of the special tribunal is also one of key tasks of Ukrainian diplomacy, which Mr. President set for us in the end of 2022. So this is one of the main tasks for us for 2023. We do believe that it is important to investigate and prosecute the crime of aggression against Ukraine, because we do believe that it is a way forward to breach the impunity of Russian political leadership. We know how conservative international lawyers and international law can be, but we do believe that in such a situation, we shall not find excuses. Why not do something? And we shall not use the obsessive formula, go and use tools which you have. Because we as a government use all the possible tools to bring Russia and Russian citizens to responsibility since 2014. So we know how to use all the possible international courts and tribunals in order to get Russia to accountability. International Court of Justice, recognition of jurisdiction of the ICC, UNCLOS Convention tribunals, International Tribunal for the Law of the Sea, investment arbitrations, European Court of Human Rights. We use each and every possible tool since 2014. But it is obvious for us that it is not enough, that whenever we need to talk about comprehensive accountability under international law, this element of accountability for the crime of aggression is of key importance. Moreover, we also do see that whenever we talk about particular investigations of particular war crimes committed by Russian soldiers, say in Bucha, Irpin, Hostomel, Izium, it will be, I am sure of that, really hard to prove and to find out, to establish the linkage between a particular war crime committed in Bucha and an instruction or an order from Kremlin, Lubyanka, or some other high authority there in Moscow. We may also see this in practice. Let's take results of investigation of the International Criminal Court of the situation in Georgia. 3 arrest warrants to low and mid-level so-called South Ossetians occupation administration officials. It is needed, it is important, but we do believe that the crime of aggression is a tool which can bring us directly to the top. So without spending, of course, a lot of time, I will try maybe to move fast around the questions which our moderator set for us. So Ukrainian vision of that tribunal. As of now, our official position is that all the options are on the table. And we are now discussing and considering which option might look the most feasible and the most effective one with our international partners. It is very important that now we started to get feedback in relation to attitude of some particular states towards some particular options. It is very important for us because we do not want to choose alone an option which will not fly. So all the options are on the table, and obviously these options are establishment of the tribunal on the basis of agreement with UN. And there, of course, the relevant question is whether the UNGA, UN General Assembly, does have powers to do that. There are different points on that matter also in international legal practice now. We do understand this well. The second option is to have this tribunal on the basis of multilateral treaty between states, which does have some benefits, but might have also some cons whenever we talk that there may be some mirror decision by the Russian Federation. Though, frankly speaking, there may be any decision by the Russian Federation, which shall not be concentrated on their counteractions. Third option is to have something on the basis of European approach with participation of EU and the Council of Europe. And here, I think the interesting point is that the Council of Europe, I think, does have moral and legal background to do something in this relation, because Russia was a member of the Council of Europe when it started full-scale invasion. So whereas some organizations may be engaged where Russia is not a member, but Council of Europe, I think, does have this role. Of course, we do hear quite often the questions, how about the hybrid format? So, of course, we all understand that hybrid format are just words. It means that it is something based on national jurisdiction, national law. But of course, in each and particular case, hybrid tribunals are individual decisions. For us, hybrid option looks a bit tricky, and we are very cautious about it due to several issues. First of all, because of the seriousness of Russian violations of the UN Charter, whether a response to that in the form of a court which will render decision or verdicts in the name of Ukraine will be appropriate to the biggest war of aggression in Europe since 1945. And of course, the other issues arise in particular about immunities. Obviously, within the hybrid formats, this issue, of course, due to the fact that crime of aggression as a leadership crime arises more than in other options. But I must admit also that the issue of immunities of Troika, as far as we do have these consultations with different stakeholders, the issues of immunities of Troika does arise whenever option we talk about. So this also goes about the base. Yes. So all the options are on the table, and it's up to the model we choose to find out the basis. What is important is that Ukraine gathered a core group of like-minded states, which we believe will be of assistance for us for finding solutions in this relation. So we believe that with that mechanism, we'll be able to using consultations to move forward. And concerning the crimes which we think this tribunal should have jurisdiction over, we believe this should be crime of aggression, because we do not want to duplicate the functions of national courts and of the International Criminal Court. We do not want to invent the fifth wheel to the car. We are very happy with cooperation with the ICC. We have recently amended our criminal procedural code, which now does include a chapter on cooperation with the International Criminal Court. Our prosecutors have daily contacts with the prosecutors of the ICC. Also, we are now negotiating an agreement on opening the field office of the ICC in Ukraine. So ICC is a priority, is a principal organ of international justice for us. But we do believe that we cannot leave behind the crime of aggression. So our idea is to have a mechanism which would be complementary, supplementary to the ICC, and would focus only on the crime of aggression. I would finish up maybe with the thing said that with assistance of international academics, experts, professors, international lawyers, practice professionals, we have prepared a draft agreement and draft statute of a special tribunal, which actually is more or less feasible for each model or option which we choose. So it just like has variants A, B, C, D. So we already do have a background on which we can build whenever we talk about the establishment of a particular mechanism. So now we are on a stage where we are transferring ourselves, I would say, from political debate to legal and technical discussions in order to find the feasible and effective solutions. So here I think I will stop, but of course, if your format does have questions or comments, I will be happy to try to answer to them. Thank you.
Certainly, I'm sure there will be a lot of questions and discussions, but first, let us present the idea and then we'll start to comment on this and discuss this. So as a second, I would like to ask for your comment and opinion, Professor Zavrukha, Southwestern Law School.
Hello to everyone, and first of all, thank you. Dziękuję serdecznie I dziękuję for the opportunity to listen to you and to share with you my perspective. I also, in response to the interesting talk of Ambassador Korynevych, want to thank Ukrainian government and Ukrainian lawyers and international jurists from around the globe for literally exhausting every tool and every option that we have in international law by today, and using every forum to have the crime of aggression recognized on every possible level, because that's the first step toward to secure a legitimacy of the future tribunal. As we all know, Russia and Belarus complicitly have violated one of the core principles of the United Nations Charter, which is the prohibition of the use of force against the territorial integrity of another member state. And I don't seem to get tired to remind and to say that Russia has destroyed every pillar of the global architecture of international law and order. Such principles as sovereignty, as we understand sovereignty throughout the centuries, sovereignty, territorial integrity, non-intervention in internal affairs, prohibition against the use of military force, international cooperation, and respect for human rights. Russia brutally abused the concept of the right of people to self-determination, and ultimately Russian President Putin committed the crime of aggression. And those are established principles of international law, and they are abused, breached, and the global order is challenged to its core. And we find ourselves in the position where existing mechanisms do not work, or they are not efficient enough, or they simply do not exist. And that's why I really wanted to thank you for exhausting all possible options, because that's what we are facing. There is not enough. The world was not ready for the challenge like that, for obvious reasons also, because the system, the global order, outlived itself probably it outlived itself with the beginning of the Cold War. And I'm talking here about the Security Council and the efficiency of the United Nations. So I would like to talk about the tribunal, but having in mind the whole framework, the whole context within which we act. So we have to be creative, but within this existing format, even though it's imperfect. But in order to secure legitimacy is a key here, because we don't want to have questions and accusations that the tribunal or the action lacks legitimacy. So it would be ideal if the crime of Russian aggression was tried by the International Criminal Court. That would really be the best. And I appreciate the fact that this option was and still has been discussed. But I don't think we can overcome existing obstacles unless Russia would be expelled from the Security Council, and here I want to remind that the Soviet Union was expelled from the League of Nations back on December 14, 1939, in response to the Soviet invasion in Finland. And I know this is not exactly subject of the conversation, but I still want to make a point that we need to proceed on every front, including the reforms of the United Nations, and to get to amend the Charter of the United Nations. So having said that, the imagining that the Security Council refers case to the ICC, we still would have some jurisdictional issues, including temporal jurisdiction as well. So the alternative must be found, and it is the criteria of legitimacy is the most important one. And thanks, Ambassador Korynevych, for giving this for brief review of different options. They are different. They started with the coalition of the willing. You know, the nations can join ad hoc tribunal. We have discussion in the Council of Europe. The European lawmakers are drafting proposals to create tribunal in Europe, which we can call as a regional tribunal. And I want to stress that for purpose. I will return back to it later. There is also not only mechanism of establishment is under discussion, but also the form, the shape of the tribunal, hybrid, domestic, or international. And the last in my list is the options that I wholeheartedly support and agree with, is would require the involvement of the General Assembly of the United Nations. And the United Nations General Assembly resolution and the statute for a special tribunal formed by the United Nations in Ukraine, again, the mechanisms would have to be discussed in greater details, and whether it would designate the special role of the Secretary General, of course, but it also probably would have to take a vote. And here we look for the history, and we know the General Assembly played role in establishing tribunals for Sierra Leone and Cambodia, but those were hybrid tribunals, so it is a little different. And here again, it's a question whether on legitimacy, whether General Assembly has authority to do that. And of course, the answer to this question might not be 100% satisfying in terms of black and white law, in terms of straight formula, but it doesn't lack legitimacy, as for me. Maybe we do lack a little bit of legal context and legal ground, legal basis, but not legitimate one. So there are few obvious reasons why the General Assembly should step in. First of all, General Assembly is empowered by the Uniting for Peace resolution. And as we all know, or most of us know, that the General Assembly is within this session on Ukraine, so we don't even need to call for a new session, and it broadly opens the horizons of the General Assembly. It does give the power to General Assembly to step in if the Security Council is not efficient, and if there is a threat to peace, breach of peace, or act of aggression. And here we have pretty unique situation when you look at the history. We have pretty clear terminology. We all know that threat to peace is a little vague category, but when it comes to the aggression, we have definition issued by the resolution of the United Nations, and we have a Rome Statute that actually is the work on a norm on a crime of aggression was so thorough, was so well done that it really encompasses a customary international law. So I don't think we have too many questions on that subject. And of course, nobody doubts that Russia did commit act of aggression. So the definitions are clear, and the fact that the Security Council is not able to perform its duties is also cannot be more clear because of the veto power of Russia. And literally, the Uniting for Peace resolution says if the Security Council, because of lack of unanimity of the permanent members, fails to exercise its primary responsibility for the maintenance of international peace and security, in any case where there appears to be a threat to the peace, breach of peace, and act of aggression, the General Assembly shall consider the matter immediately with a view to making appropriate recommendations to members for collective measures, including, in the case of breach of peace or act of aggression, the use of armed forces when necessary. So another obvious reason why General Assembly's vote would have the highest level of legitimacy is because it includes literally every state, or almost, let's be precise, almost every state in the globe. So that's a very powerful motion. And again, when at the first United Nations General Assembly, at the first meeting, there were 51 member states present, and today we have 193. The world changed dramatically, and we have to honor that motion and push it forward. So that's one factor. Then going back to the Uniting for Peace resolution, we have excellent history of voting in General Assembly in favor of, let's say, not condemning Russian aggression in strong terms. Another point on this is, of course, criminal justice is super important. Accountability and justice are essential. There is no peace without justice, as we all know. But criminal justice is only one puzzle, again, of the big picture. And trying to find the mechanism using General Assembly vote, we also will make a precedent for solving other issues, even within Ukrainian case. We are all thinking now at the same, on a parallel track about reconstruction, recoveries, reparation, and again, we need a mechanism. We are thinking about the mechanism for those commissions, for that commission, in a similar way as we are looking for the solution of the ad hoc tribunal for the crime of aggression. So that would actually set a pattern, and we would be consistent. The General Assembly takes a part in establishing of the ad hoc tribunal and establishing the commission, claim commission on reconstruction, recovery, and reparation. So we basically now have to push the global system to reform, because it's basically two ways for us. Either we don't anticipate anything real from the Security Council and the United Nations, just give them a forum and, have historical record of debates, or we recognize that post-World War II order outlived itself, and here is time for reforms and time to reform the Security Council. I don't think we need to be that much afraid of that. And I would like to remind you here the quote of the delegate of France during the last session of the Assembly of the League of Nations, who said that it was not the League which failed as a predecessor of the United Nations. It was not its principles which were found wanting. It was the nations which neglected it. It was the governments which abandoned it. And here we have similar situation with Russia. So it's either we reform the United Nations, the Security Council, either it will just will repeat the history of the League of Nations. Another important role for ad hoc, besides bringing perpetrators to accountability, is historical record. And that the trial on the crime of aggression would have major historical impact on the future, not only for Ukraine, but for the whole world, including Russia in the future. We all witness, and actually every state is the victim to some extent to the Russian propaganda and how Russia uses the tools for Russian propaganda. And again, as an element of transitional justice, I think that ad hoc tribunal on crime of aggression has this role to play for the future history, and it will be because if we fail here, it will mean to some extent that even Nuremberg trials failed, because that's why Nuremberg trials were established to crystallize a crime against peace. And just few more words that I was thinking about the International Court of for former Tribunal for former Yugoslavia, and one of the first cases, Dusko Tadic, when he questioned, when he challenged the jurisdiction of the International Criminal Tribunal for former Yugoslavia. And of course, this year, we all read this case differently than we perceived it years ago. So Duško Tadić challenged the legality of creation of international tribunal through the Security Council, rather than through multilateral treaty or some other mechanisms. What an irony, right? For us, it feels today that if we had Security Council vote, all our problems would be solved. But not that long time ago, it was a question, did Security Council have this authority to establish judicial body? Was that intention of the founders and of the United Nations? Was that intention of the drafters of the charter? Because they worked on a Nuremberg tribunal basically during the same time, but they didn't include that power into the UN Charter. And then really you don't find literally the text that Security Council can establish the judicial body. And obviously the trial chamber was a little confused with that. And they concluded that they don't have the authority to adjudicate the challenge to its own legitimacy and dismissed Tadić's claim. And then later, the appeal chamber actually argued the ability to adjudicate its own creation by the court, and they supported the principle competence de la competence, that the court can decide on its own jurisdiction. And then they showed the example how they, analyze the legitimacy of the creation. So my point here is that we shouldn't be afraid, because this is the time to create the new body anyway. As Nuremberg Tribunal was new, as an international court for former Yugoslavia was new at that time. So all we need to care is the legitimacy. And I think the General Assembly, just because it's a collective body of every state in the world, or almost every state, that would secure itself the highest level of legitimacy on the establishing of ad hoc tribunal. And in terms of personal jurisdiction, I think the language is pretty straightforward on the crime of aggression, and it would be it's a leadership crime and leadership clause, and we are talking about persons in a position effectively to exercise control over or to direct the political or military action of the state which committed the act. Such definition is a part of customary law, and so it's individual liability, leadership. I don't think there is a need to specify citizenship. And the principle of immunity must be embedded into that. So I think I exhausted my time. I will be happy to answer the questions. And thanks again for allowing me to be a part of this discussion.
Thank you very much. And now I'd like to hear comments of our American colleagues. So maybe Professor Wortham, if you have take the floor as the first, and then Professor Waters. Leah, can you hear me?
Unmute myself. We've heard wonderful analyses of the important public international law issues involved, and that is not something on which I'm going to comment or have deep expertise. I want to pick up on a theme that Professor Zavrukha has just addressed, but from a different perspective. Ultimately, of course, legitimacy is a central issue. One wants for all the purposes, wants to achieve with a tribunal the legitimacy of who decided, how it was decided, and its record is central. Thus far, the comments have focused a lot on legitimacy that comes from the form of creation. Who creates it, the instrument that creates it, which is, of course, extraordinarily important. Much of my career has been spent in legal ethics, structures of legal professions. I'm currently a reporter for a European Law Institute project on judicial independence. So that's the lens through which see what I'm talking about. And so I've thought about these issues more from the perspective of national courts than from the perspective of how those issues are judged in an international fora. Although I think the fundamental issues are really the same in terms of who appointed, who created. That's a big piece of whether something is legitimate, the degree of actor of politics in the action and so on. I want to move, though, to a couple of things that go beyond the fundamental piece of how it's created, what instruments creates it, a tribunal who creates it, but the way that legitimacy comes from the way it operates. And that moves more into the topic that I was asked to talk about, which are about who the judges are, who their qualifications are, how they're appointed, what their security of tenure is, what code of conduct they would have, because those are also issues that are enormously important ultimately to legitimacy, because you can create a wonderful court, and we all know we've had instances where then some individual, because of the way they act or some incident that happens, then questions the credibility of the institution as a whole. So those are later issues to come, but they would then be enormously important issues in terms of how you set up the criteria or who would be chosen, which qualifications are necessary. Is it important that they have deep expertise in the international law issues here, or is it more or greater importance that of their stature as a jurist, their reputation for fairness, what countries people would come from? All those things then become very important. I want to link this to another point that Professor Zavrukha has stressed, which is, what are the purposes we're trying to serve? I hesitate to say anything about criminal law in the presence of Professor Vrubel, who is a towering figure, as we all know, in criminal law. I, however, treat criminal law for a while, but in a very much less important way. We all know, though, that the fundamental things we talk about in criminal law are deterrence, retributive justice, restorative justice, and those go in many ways to the individual impact on the society. But I think in Professor Zavrukha's comments, if we look at historic tribunals and why we want this tribunal to be important, you move to other factors: education, the historical record. Those are broader issues than what happens in, an individual adjudication. So I think it would be important from the beginning, because it seems to me in today's world, I would think we're probably talking about a tribunal whose proceedings are streamed, or at least some of them are streamed. I'm thinking about, I just thought about the January 6th Commission. One of the things that I think the world, in thinking about the January 6th Commission, has said is that I think there's no doubt that a great deal of thought went into how are we explaining to the public what this is about, and what were really the fundamental issues at stake. And of course, that wasn't a court, that was a commission. I understand that. At the same time, if we think about the Nuremberg trial, a great deal, and think about what would happen if the Nuremberg trials were there today. Rebecca West wrote a famous book about the Nuremberg trials. There have been movies made about the Nuremberg trials. As I said, I would guess this tribunal would probably be live streamed. And one of the things that one, I think, would have to think about in terms of the procedure is what story is being told to the public about what the issues are at stake, about what rights defendants have, the whole set of things, because we all know that, many things that happen in courts are mind-numbing and very routine, and it would be very easy for a public watching those proceedings to just get lost, not understand what they're about or what their significance are. And I think one thing that is a very difficult overall question about how these matters are adjudicated is, of course, one is thinking about the defendants being tried. I think, though, one of the things we've been talking about is probably much more, in sense, more important, is the implications of what this is saying about what's a crime, the implications about what the world believes it can be done, and to just help make it concrete for a broader public at large of what the issues really were in a broad context. I think that then, so again, I'm talking about a lot about legitimacy and operation, and I think that would become, a very complicated, and the people who were involved in it would be, I think, also people like people on this webinar who are experts in the past tribunals, in the EICC. If we look at how they do those things in a day-to-day procedural way, in a day-to-day operation way, will that achieve the objectives we want to achieve for this tribunal? And that doesn't mean that they're not doing the right things for what they're doing in their own work. Are those the things that are important to be achieved by this tribunal? Because it does seem to me that there is this really huge purpose in education and historical record and establishment in terms that the world at large could understand of what this meant, to the world order and so on. And there is such an enormous selection question then of what kind of evidence we're talking about, what kind of proceedings we're talking about, because it is very different from just trying an individual where our major concern is that society's interest is served in a fair sentence and the defendants are in a fair trial is served. Seems to me this tribunal's got a number of very important additional factors, and how you balance those is a complex issue. I think I'll almost stop there. The fundamental question of one kind of legitimacy is the independence and impartiality of the tribunal. And that has to do with both the independence of the entity as a whole and the independence of the individual judges. Then, you need your set of things about what are the stated criteria for qualification, how are those judged, who decides. You do need a code of conduct, I think, of it. What past acts would disqualify someone? What, do people, if people already have a stated position, they've written extensively about X, does that disqualify? Does that just make them more qualified, or does that make them to seem to have prejudged? I think those are, complex issues for which I'm not saying there's an answer, but I think they're things that would have to be thought about very carefully in setting up the tribunal. Because again, as Professor Zavrukha stressed, legitimacy is really an enormous piece of it. Public confidence is always an enormous piece of what happens in any court. And here we're talking about public in a very broad and ominous way, the world and future generations. So I think I'll stop there.
Thank you, Leah, so much. That was really very inspiring. And I think that in the next steps in our discussion, we'll return to these issues, especially from this point of view that Ambassador Korynevych just told us, that we are still discussing and thinking about a specific tribunal to be competent in only one crime of aggression, telling the truth, yes. And that changed also, I think, our perception of the whole tribunal, but it concerned as well the judges and the aims of it and the legitimacy, I think, as well. I'd like very much to hear the comments of Professor Waters now. He didn't know that he will be a panelist in a way, but I hope that he could have some suspicions on that while being invited by me to this discussion. So Tim, the floor is yours. What are your thoughts about what you've heard?
Well, thanks so much. It's delightfully freeing to not have known I was going to be a panelist, because now I am an incredibly low bar. So that's wonderful. But this is a great conversation already, and I'm delighted for the invitation, the chance to join with you. It's really a great opportunity. So I think so we just heard something about, and I agree, these important questions of legitimacy in terms of the procedures, things like the selection of judges and so forth. I do want to talk to legitimacy, but in a more general sense, at least as a sort of first cut, in line with the comments of our first speakers, as well as sort of my own perspectives on this. So just to note, I think Ambassador Korynevych mentioned that this has been a rapidly moving debate, and that's true. I mean, moving from just complete hypothetical ideas to things that start to look like concrete proposals. It's become much more possible. I think that's right, as a function of what's happened over the last year. And if we think about legitimacy, he mentioned now that this is a now or never kind of moment, right? That we should, if we don't do this now, it may never happen. And I want to think also about the legitimacy that both Professor Wortham and Professor Zavrukha talked about, in terms of both the formal legitimacy that comes from what is the pathway of setting this up, what are the, whether it be the General Assembly and so forth, but also here I agree with Professor Zavrukha. I think in some sense those answers ultimately resolve themselves by a kind of an act of will. That is to say that legitimacy, or at least the claim of it, comes from assertion. And we can see this going back a long way to the earliest attempts to set up judicial responses to conflict. People like Clemenceau at Versailles are openly claiming that this is a new model, not based on precedent, but a leap. And I think that's very possibly what's going to happen here, in part because international law is so completely contested and amorphous that the legitimacy can come from simply saying it, and of course having the power to back that up. And so with that in mind, I remember I noted that Professor Korynevych, Ambassador Korynevych mentioned that all options from the point of view of Ukraine are on the table. Clearly some preferences within those all options, but a realistic state in this situation is going to listen to all of them. And with that in mind, also as was mentioned, exhausting all the options that are out there, different courts and so forth. But I want to turn to this theme of exhaustion that Professor Zavrukha mentioned. And the problem that, which I think is true, that the institutions we have are not capable of, ready for responding to this issue, which is why we're talking about a new court, that the institutions we have can't do this. And I won't recite why, that's already been mentioned. I think we all know that. I would say, ironically, so Professor Zavrukha mentioned the League of Nations. I actually think, despite its reputation, if you look at the security provisions of the League of Nations, they're actually much more capacious and flexible than the ones we've been living under for the last 70 years. They actually have opt-outs, options for states to engage in violent response around the decisions of the council that is simply unavailable in our current model. So in some senses, we have a more rigid, less useful model today. So if you think the League was not a success, you should be somewhat pessimistic about our current system as well. And as I mentioned, these debates actually go back before the League. I focused on World War I a lot. I teach on that. And the aggression debates, the debates about having what we would call an aggression tribunal occurred then. And so did the same objections that we can recognize up to today, all the way through Nuremberg, through the Rome Statute, through Kampala, and the final grudging creation of a jurisdiction to this day. You can read the reports from Versailles, and they are strikingly contemporary in terms of the objections and concerns that arise. And I think that's significant. I'll come to that. So I want to say something about legitimacy, and here, not so much because of the forum and where we're sort of centered as a community, but I was thinking about when just now when Professor Zavrukha mentioned legitimacy. Some of you will doubtless know the well-known Polish-American statesman, diplomat Zbigniew Brzezinski wrote a famous, very influential book about the Soviet Union, which posited that this was a state forever trapped between the move towards legitimacy and authority. that it could have one but not the other, right? Authority meaning a kind of power-based authority as opposed to legitimacy, which has some normative quality. And I think that's a useful lesson to keep in mind, not just because he was Polish or writing about the successor to the state that's now engaging in aggression, but what that says about how we think about legitimacy in the international sphere. And I want to bring this more concretely to our discussion here. So we've heard a couple comments about maybe making this tribunal through an international agreement. And behind that, implicitly, the concession that were this to be done strictly by Ukraine, there would be serious legitimacy issues with that. There would be many objections from many actors as to why this wouldn't really be international law, the international community speaking, or something we should take seriously. I think that's pretty clear why that would be the case. We know the Security Council is an impossible pathway. The General Assembly, as we've already heard, maybe can do this. I think it's safe to say that is a highly controversial and questionable argument, but I want to punt on that. As I said before, I'm in the assertion camp. I think if the General Assembly were to do this, I guess that would mean they have the power to do it. So I don't find Uniting for Peace all that persuasive, to be honest. I think as a doctrinal matter, it doesn't create all the things we think it does, but it is true as a sort of political, sociological matter that when states say it does, that's the source. Really, we can't get down below that. So I'm not so worried about that. I'm not a doctrinalist in that sense. I am a little unsure. And I would add, you mentioned Tadic. I hope we'll get back to this. Tadic, of course, is a great and fascinating case. It is ironic that we're now in the position of reversing that, but there might be a different lesson there. For one, it is the Tadic interlocutory decision about the court's authority, as I always tell my students, is the least surprising judicial decision in history because the court discovered that it actually has the authority to continue working. And this is the assertion argument again. If the General Assembly makes a tribunal and then some hapless Russian gets dragged before it, he will raise an objection on whatever grounds the court has been created, and it will be rejected. This is sure. It doesn't actually mean that that legitimacy is going to be purchased by anyone outside the court, of course, but we'll get that far, for sure. I am not sure we're going to get that far, though, because it's not a question of the legitimate, doctrinal legal authority of the General Assembly. But as was mentioned, I think, will you even get a majority? I think this is really unsure, and the reasons why are important to our thesis about legitimacy more broadly in international order. There are already, 140 some states that voted for the resolution, overwhelming, but everyone knows if you read the resolution, highly qualified, the language is not actually the maximum that diplomatic language could have been, deploring instead of condemning and so forth. This was clearly a very carefully, despite appearances, watered down statement. And even so, 53 or so states, whatever it is, didn't join on, including enormously powerful ones. So already we have a sizable chunk that would be there to defeat our majority. And as I think was mentioned, there are more states that will defect if we move from deploring what Russia has done to creating a court. Absolutely, we could expect those same states to vote against it, but many others, including at least behind the scenes, the United States, France, and UK. At an absolute minimum, maybe France and UK would ultimately vote for it, but they would most assuredly work to water it down, qualify it, cabinet, narrow it to the point where if this literally became a tribunal solely for the purpose of trying this country for this crime, those of us talking about legitimacy would, I think, at some point among ourselves, while we supported it going ahead, have to ask, what is this exactly worth if this is our legitimacy project? We might get that, but we're not going to get a tribunal of general jurisdiction. And I'm not sure that getting one of special jurisdiction for this case only is doing the sort of work that we would imagine it to do. I don't suspect that builds for the future, quite honestly. Maybe it would. But my main point is, I'm not sure we'd even get there. It's a pretty likely chance, I'd put my money betting that we would ultimately not get there because it would run into the sands. There'd be so many countries openly or quietly opposed to it, watering it down. I have to say, the Council of Europe proposal, I think is really fascinating, precisely because it would limit this to Europe, and that would be sort of politically useful. But it seems like that's an extraordinary act of assertion, and one I just suspect wouldn't actually happen. I could be wrong about that, but it would be more limited and it would at least solve sort of the geographic awkwardnesses that come with saying we're going to try aggression, and by the way, only for Russia. And as was mentioned, I think I just want to pass over the immunity issues. I think it's safe to say they're not automatically resolved. These are actually really problematic as questions of law and doctrine. But I think once again, they fall into the assertion camp. They will be swept away if we create this, I think, safely enough. But we should have in the back of our minds a little thought, if we're concerned with legitimacy, like with Nuremberg, which has never quite solved that problem. It's an enormously illegitimate enterprise in many respects, and most people know it, that we're not going to make, shall we say, true deep legitimacy go away just by making this thing. Last couple of things I want to note so we can have back to the other speakers and comment discussion. I think the ambassador is right that this has become amazingly more possible across the last year. I'm not sure that's actually an optimistic note in terms of our international system and its institutions. It has become more possible because of the results of the war. Right? This is a direct consequence of success on the battlefield. And all that comes with it, including the piling on of diplomatic support, military, material support from other states. And that's a reminder that the driver of this project, I mean, specifically the court as a reality, a potential reality, is military success. And law and legal justice really is going to be what we would call, like in economic terms, a lagging indicator of that change. It's not driving it, it's being driven by it. And I suspect that means its legitimacy is really just sort of a proxy or an epiphenomenon of something else. I'm very focused in my thinking on the fact that we live in a system of power, not of law. And that means that these are, I ain't no Marxist, but these courts are kind of superstructures on top of what's really driving things. Okay. I wanted to signal the debates, not so much answer them. If this is a court of war, as you would say, created by war, we're going to have to think about the Nuremberg problems, about context like victory. Do you need victory for an effective court? I know of no court that has been maximally fully effective without full victory. None of our international courts are unqualified successes on those narrow grounds, except for Nuremberg and Tokyo, for whatever it's worth. And these are courts of the context of victory, whether you want to call them victor's justice, I don't care. But we need to think about what a court can do in the absence of victory, which I know of no scenario in which victory will be total. It seems very unlikely of the kind that we got for Nuremberg. And we may face the kinds of geopolitical stalemates in which this court would be operating absolutely without capacity and authority in the target zones in particular. Last couple of things I'll say, I'm coming to my conclusion. It was mentioned here, I want to take issue. I think Professor Zavrukha mentioned the concept of no peace without justice. Well, I agree, we all know about it. But hopefully we all know that actually peace happens without justice all the time. This is actually the default norm. Peace without justice is a slogan, right? And one to promote international law projects. But it's not a realistic description of the world in which we have ever lived or live in today. And that brings me to Professor Wortham's points. There are lots of other factors at play here: education, history, other ways to deal with and process conflict and atrocity. And I'm very skeptical. This is something I actually do work on. I'm pretty skeptical that these courts are useful or optimal ways to build the historical record, to educate people, and so forth. If we look at the ones I know best, the ad hoc tribunals, they have singularly failed to do this, especially with their target audiences in the former Yugoslavia and Rwanda. They have not succeeded, and it's even been conceded by the judges and other supporters themselves. So I don't know that we should be investing in a court for that purpose. But it's worth noting that's a very common purpose people attach to these courts. And here I note the ambassador mentioned, I think quite sensibly and rightly, that from the Ukrainian perspective, these courts are tools of diplomacy. They're tools. Well enough. That reminds us that courts have purposes, and we need to think about what they are as we build them. Is this for justice in some general sense? Justice for Ukrainian victims? For, as was mentioned earlier, the whole world? I know we're all victims of crimes against humanity, but I always feel a little nervous about that because the actual non-metaphorical victims are much more affected. And if we start to create a court that is increasingly in the international sphere and for an international audience, it stops being about the people who are actually affected. Okay, that's a purpose we can point to. Is the purpose of this court to facilitate a Ukrainian victory? I am sure that it is from the point of view of many Ukrainians and many of their allies, and I have no concern about that, apart from the fact that the lawyer in me that says courts should not be about serving political goals. But that is a goal, and that might suggest different designs. The last one I would think of, which again, Professor Wortham reminded us of, this court this idea of a court is reaching towards some very grand purposes, right? Preserving the international order, reasserting truth, and so forth. And in my reading of history, when these courts seek to do great and grand things, they tend to fall very short. I'm personally an advocate of very limited forensic models where they look more like domestic courts, or they're actually just trying crimes and not telling stories. But we are clearly back in full narrative mode with our projects for these courts. They are to preserve the global order of justice. That is a gigantic project, and we should quite honestly expect failure if that's what we aim for. So to conclude, just a last point. I completely agree that legitimacy is the core of this, and I think it can be achieved by self-assertion. I'm not worried about the doctrinal pathways. If there's politics enough, support enough among the many actors in the pro-Ukrainian alliance, we'll come up with some way to paste that over. Because international law is so thin anyway that why should we worry about this? But it's worth noting, again, remembering, I gestured as far back as World War I, this kind of thing has always proved difficult. Professor Zavrukha is right. Our current institutions are not up to this. Why is that? Right? Why are we 100 years into our great project still with institutions that can't? I suspect that is because there's something endemic in the nature of our global politics that means we will not have, not a question of what I want, but what I see and predict. We will not have institutions fit for this kind of purpose, except for in the most ad hoc, hyper-politicized, instrumentalized way. Is this the time for reform? Yes. As the ambassador mentioned, it's now or never. I'll close with this. It reminds that line appears in one of my favorite novelist books, Anthony Trollope, the great Victorian novelist. In one of his books, a wonderful weak-minded bishop decides he must confront his wife, and he says, "It is now or never," and he knew it could not be now. Okay, I'll stop there.
Thank you very much, Tim. And in the meantime, Professor Geoff Watson joined us. So I would like to welcome you warmly. Thank you for your presence and willingness to share with us your opinions, comments. The general idea of the court was already presented by Ambassador Korynevych, and the idea is also known to you very well. So the floor is yours, and we hope for your comments now.
Thank you very much. Can you hear me okay?
Yeah.
Yeah, great. I'm sorry I arrived late, so I only heard the comments from Professor Wortham on, so I apologize in advance if I repeat comments already made by others. Indeed, Professor Waters already sort of stole some of my thunder because I share a number of his views on this. By way of background, I teach public international law and I've taught international criminal law. I practiced international criminal law at the U.S. State Department in the 80s and 90s, and I sat behind Madeleine Albright as she voted for the first international war crimes tribunal since Nuremberg and Tokyo, the International Criminal Tribunal for the former Yugoslavia. And I've written about that tribunal, and I have a somewhat more upbeat assessment of its record, I suppose, than Professor Waters does. So I'm a fan of international courts. I'm a proponent of international criminal courts in particular, and so I'm the sort of person who I think is the target audience in some ways for this proposal. I like the idea of international criminal courts. Ambassador John Bolton, by contrast, does not. There's a significant there are a significant number of Americans, at least, who are opposed to an international criminal court and opposed to international criminal tribunals more generally. I'm not one of them. So I'm inclined to be supportive of the idea, but even I have to say I share a fair bit of skepticism a fair bit of the skepticism I've heard already. One reason, of course, is I worry about weakening the International Criminal Court. I worry about setting precedents that say we don't think the ICC is good enough. We're going to establish new courts on an ad hoc basis every time a new international criminal problem comes along. I'm not saying the ICC is perfect, but it has at least taken some steps forward on Ukraine. It conceivably could, I think, play a role in prosecution, at least of some lower level people for war crimes, crimes against humanity, and genocide in Ukraine, and perhaps higher level people as well. And I know the proposal is not necessarily to stop the ICC from doing anything, merely to perhaps just supplement it by providing an ad hoc tribunal in particular that has jurisdiction over the crime of aggression. And I won't repeat Professor Waters' comments about the sort of long, tangled, controversial history of prosecuting a crime of aggression. But I will say that if that's to be the principal purpose of this tribunal, I worry about it. Maybe I'm misunderstanding it. When I teach public international law, one of the first cases we read is the Nuremberg Tribunal's case applying the ex post facto principle to the crime of aggression, or applying it more generally, but particularly the crime of aggression. And the case holds that, well, because the Kellogg-Briand Pact had already outlawed the crime of had already outlawed war. Therefore, Nazi officials were on notice that initiating a war and conducting a war in certain ways was unlawful. I ask my students, are you comfortable with that holding? Nobody wants to say they agree with the Nazis about anything. So the students, sort of sit there quietly, uncomfortably saying, oh, well, I don't know. But there were plenty of other grounds for convicting the Nazis, crimes against humanity and genocide and war crimes. Those all carried plenty strong punishments. And the ex post facto dimensions of criminalizing the crime of aggression after the war has started trouble my students. And they trouble me too, and they might trouble me here too. Not that I have any love for Vladimir Putin. I think what he's doing is barbaric and wrong, and I think he's a war criminal and worse. But I also believe in law, and I have trouble getting my head around how a court would establish its legitimacy by saying retroactively, we're going to prosecute Vladimir Putin for a crime of aggression, when that has only been rarely done in human history. And in the most famous, prior circumstance, it was, I think, a little problematic. So that's my overarching point, is a little concern about a lot of concern about the ex post facto dimension coming from someone who supports international tribunals, and unlike Professor Waters, or more than Professor Waters, thinks international criminal tribunals can tell a story that's useful. I think the ICTY, the Yugoslavia Tribunal, for all its flaws, did at least tell some sort of story. I think we were better off having it than not having it. Turning sort of more generally to the problems, the political problems of establishing a court, Professor Waters has already run down most of those. The UN Security Council is not going to establish such a court. I also am a little intrigued by the Council of Europe idea. I still think that's, for my lights, that's not a broad-based enough political solution, but I'm not a politician. I'm not an expert on European politics. I did want to comment a little more on the UN General Assembly idea. I worry about getting less than 90 votes for this idea. partly because of the ex post facto problems, partly because of the problems Professor Waters outlined, sort of doctrinal problems that states will use as an excuse. So uniting for peace is problematic, some of the Permanent Five might say, or instant custom is problematic. We can't make customary law right just by one vote in the General Assembly. But just politically, if we can't get more than 94 votes to endorse reparations for Ukraine, right? One of the UNGA votes, maybe I'm wrong about this, was for endorsing reparations for Ukraine, and only garnered 93 or 94 votes out of the General Assembly. If we can't get that, and another resolution to remove the Russians from the Human Rights Council, also less than 100 votes. And as Professor Waters, it says if the court resolutions condemning Russia's conduct only get 150 odd votes, and those are watered down, how are we going to get more than 80 votes for an international criminal tribunal with jurisdiction over a crime of aggression, a crime that scares, that in foreign ministries around the world has to send shivers down the spine. That is, in my own foreign ministry, the State Department, I can't imagine my State Department being enthusiastic about, maybe I'm wrong, but when I worked there, there was a lot of nervousness about setting precedents that might lead to an American president being tried for a crime of aggression. So I just wonder about getting those 90 votes, and I wonder whether my own country would be one of them. Maybe under Joe Biden it would. Under Republican, there's no way it would be in 2 years. So if you're going to do this, I suppose do it fast. So I'm rambling a little because I joined late and because I mostly agree with what Professor Waters said. But those are the core points I wanted to make to wind up. That I'm concerned about the ex post facto implications of criminalizing a crime of aggression after the fact. And I'm worried politically about getting more than 80 votes in the General Assembly for the establishment of an ad hoc tribunal. And finally, I do think that international criminal courts can play a role, and that's why I support the ICC, and I'd like to see it play the lead role here. That's my thoughts.
Thank you so much. Now I would like to open the discussion and ask all of you if you would like to put any question to our panelists or just present opinion and to continue to discuss the issues we mentioned. After I've heard all these reflections, I tried to ask myself, why do we need really the court for the justice? And maybe sometimes why do we replicate the idea of the national court at the international level? Because especially when I heard Professor Waters, I started to ask myself, what might be the function of this international court? So normally, what does the court do? Find the truth, because the truth is very important for the justice. Especially the victims would like to hear that someone with authority tells what has happened, and in that way recognizes also the harm and the sufferings. This is the truth. But when we talk about the crime of aggression, and once again I'm coming back to the idea presented by the first speaker, Ambassador Korynevych. So I think that the tricky thing is that the truth, that what has happened, we saw all of us. We saw it with our own eyes. It was streamed in the internet, what has happened. It's not necessary to be proven to anybody. We all know what has happened. When we are thinking about the crime of aggression, I'm not speaking about other crimes, yes? Then what does the court do? Especially the criminal court, because we are talking about the retributive justice, whatsoever, a crime we are talking about. So the court condemned, the court find guilty. It is a symbolic way of giving our moral opinion on what has happened. Yes, we need someone with authority to say, to contemn someone else, individual or a group, whatsoever. I think it is crucial for our sense of justification that someone with authority contemns, yes, says that someone is guilty for the harm, yes, for violation of some rules, moral rules maybe. And there is a third stage, I would say, the third function. It is the punishment and execution of the punishment, and I think it is the weakest part of the whole play we are talking about, because for that purpose, also for finding the truth, telling in reality, we might have some power to execute. And on the international level, unless it is not recognized, but the person who has the real power, money and you know, police and army and whatsoever, any court will be a very, very weak body. But also when we think about the trial, how to force the witness to come, how to get the documents, without the real power, it couldn't function, yes? So I think that once again, if we see many obstacles in creating the court in a very typical way on the international level, maybe the solution is to really to go deeper and to put ourselves a question: why do we need a typical court for this purpose? But these are general reflection of mine after what I've heard. And let us start the discussion. First was Professor Kardas.
Thank you. Thank you very much. It was extremely interesting discussion, very inspiring. I'm asking myself 100 times listening to you, do we really need a special court which is dedicated just for one crime? It means crime for aggression. But I would like just to point out 2 or 3 problems for which I couldn't find a good answer. First of all, as if we are talking about the court, especially a criminal one, it doesn't matter, it's a non-national or supranational level, we're trying to find justice. Doing justice is a very hard thing, especially hard if we try to do that during the war, we just have one, and try to find a right answer for these horrible things which are with the war imminent connected. So thinking about criminal justice, we're thinking about kind of rule of law. And if it should be a criminal justice on the international level, I try to answer myself, would it be a kind of rule of law over the nations, kind of global rule of law? Question sounds very important because when I come back to one sentence which was presented by Tim Waters, sounds absolutely important. The court shouldn't be a tool serving politics. And I 100% agree with that. Rule of law, it's totally different than rule of politics. When we coming back to all these arguments, which was presented today and it's still presenting, it's very difficult to find this which are connected strictly with the law, morality, axiology, and that one which are strictly connected with the politics. Thinking about the courts, even on the international level, I try to think about law, doing justice, and rule of law. That's the first. Second one, it was totally correctly said, if we try to find a way to establish a special tribunal for the crime of aggression in Ukraine, we, on the same way, weakening the ICC. There's no other option. Of course, the answer for the question why we're thinking about establishing a special court is very simple. Because ICC, in connections with the crime of aggression, it's absolutely inefficient. Yeah, but it should be put one more question. Why is inefficient in connection with the crime of aggression? When you look at the Rome Statute and all the regulations, and we see that all the nations, they decided to create ICC, were very, very skeptical, made a lot of rules which save us from making justice or evaluating as a crime of aggressions in a different situations. It's something which is totally very special, totally unusual. So taking this point, this two, the results of establishing new court, weakening the ICC, and finding the right answer why we have such an efficiency model just now in connections with the crime of aggressions, we come to the next questions. Is there really a good reasons to going that way? Do we really need to trying to discuss about establishing the court? Third, it was said many times, if we are talking about justice, it doesn't matter on national or international level, we should have an independent court, independent judges, and impartiality. It's a very, very important and highly complicated if we coming back to the discussion about the role, model, and proposal for establishing a special court in connections with the aggression in the Ukraine. Third, it's strictly connected with the independence and impartiality. It's the question of legitimacy. And the fifth one, which is the most important for me, it's purpose. Why we are trying to find a way to establish a special court, which will be dedicated just for one kind of crime of aggression. The question was presented by Tim Waters quite strongly, showing what kind of purpose we couldn't combine with the thinking about making justice on international level. And when I'm asking myself, what would be the purpose, I see just two perspectives, progressive and retroactive. Coming back to Wojtek, you were talking about the past, evaluating the past, finding a way to show the truth, giving the satisfaction to the victim, condemned the perpetrators. But probably when we thinking about the justice, the criminal justice on the international level, important is also the progressive perspective. And on that perspective, we should try to define the purposes. What we would like to achieve, establishing the court and doing justice in connections with the crime of aggressions. I don't have a very clear answers for these questions, but I think it could be on the all of this fifth perspective. A lot of objections for trying to push the global nations to organize. It doesn't matter in which formal way. It was presented from the beginning of this discussion, at least 5, could be more, but it doesn't matter which one we decided to choose. But I'm afraid it will be a very big problem to find a good point to say it is a legitimate court. This court is going to doing justice, which would be accepted, perfectly, globally. And we try to achieve a really rational, good, argumented purpose, which we, at least I, don't see very clearly. Thank you.
Thank you. Now, Olena Shalvan.
Hello, everyone, and thank you so much for all the participants, all the comments and voices we heard. And it actually proves that this is a very interesting topic, and this is not the topic that has clear answer, because it's multidimensional, multiple issues are involved here. And I just want to focus my attention on the question that was going through each and every speech, why we need this court. And this, I would like to hear the opinion from Ambassador Korynevych, why Ukraine needs this court, why Ukrainian people need this court. And then I would like to hear from all of us as representatives of international community, why we as a part of international community need this court. And in order to invite you to comment on that, I simply would like to share my view why I think this court may be a good idea for us at this point right now. I view this court as a tool, and not tool to fulfill some ambitious or to gain some political gain or win the game. This is the tool that our international community and order is lacking, because when UN was created, there was a kind of agreement. This is what I learned, and that was my understanding. And when I was inspired by international law, that was my understanding, that people were able to sit down and reach the agreement, that those are the rules we will follow in order to avoid disaster as Second World War. And now we are here today with one of the major players or participants of that agreement is saying, no, I will not abide. They already ignored several decisions and rules of International Court of Justice. They ignored decisions of European Court of Human Rights, European Council. They ignored resolutions by General Assembly. So what is the response to that? Do we just accept? Do we try to maneuver things around, or we will try to make changes? And International Criminal Court was created not immediately after the creation of UN. There was an understanding after several special tribunals that we need International Criminal Court. And even with that court, because of different political powers and maneuvers, is limited in the scope how that institution can protect that international peace. And I would like to touch a little bit upon ex post facto. And please correct me if I'm wrong, but I don't believe this is an issue in this case, because crime of aggression is a crime of aggression. We are not creating a new crime. This is just how we are going to prosecute, convict, and punish for that crime. That's why I'm referring back to the idea of the tool, why we need that. Somebody will say, and I really like the article by Professor Abramovich, I hope you all will read it, because it's not the conclusion, but the issues that are raised. And it's very valuable, because we need to address each of those issues and arguments and concerns. And in that article, he mentions that Ukraine can prosecute crime of aggression against Ukraine participants. So why we need this special court, why Ukraine needs special court. And here we come to the big question of legitimacy. Legitimacy will be questioned no matter what. There will be always one person, one state who will question the legitimacy of this court, no matter how we proceed, what formula we'll choose. And Professor Zavrukha gave perfect example that it was created by Security Council, challenged on that ground. It will be created by the multilateral international agreement. It will be challenged on that ground. But what does it say to us? Legitimacy, if it's challenged, and why we do not want it to be challenged? Because if it's challenged, if it's not accepted, we won't be able effectively prosecute, try, convict, and then punish and enforce the judgment. But if there is an agreement that we accept the jurisdiction of that court, that's, as Professor Watson said, by self-assertion, it will be alleviated in some way. I think as important question as to legitimacy is what Professor Wortham touched upon, how the court operates, what are the procedures, what are safeguards? Because if it comes to appeal in regular courts, we know that even if there was some violation of the rule, did it have an impact? Would the decision be different if that or this rule was followed? So that said, Ukraine, I believe, needs this special court because of the scale of the crime and subjects involved in this crime. It needs expertise, international expertise, it needs international recognition, and it needs cooperation from the states. It goes to arrest, it goes to evidence gathering, it goes to communications, and then finally, execution. Like, it's not only that we want to convict Putin, but we also want to restore the justice. This is a huge element. And this court will also play the role in that to achieve. And then the practical matter. Different real estate, property, assets were arrested all over the world, but not even a single country will just release the arrested asset without some kind of an order or decision, court order. And this will be the tool. And this tool is International Special Court for Ukraine. And I'm just wondering what you think about that.
Thank you, Elena. It was a question directed to all of the panelists. Why do we need the court? From which perspective? I see Aleksandra Neprzecka on the floor. But as I understood you, Elena, the main problem is the general recognition of this. General in that way that the recognition is also connected with the willingness to cooperate with those actors who have power. That's maybe the main problem. Aleksandra Neprzecka, please, you have floor. Floor is yours.
Thank you so much. I will try to make my point quite briefly. And first of all, I must say that in the beginning, when I heard the proposal, I was very glad that the idea was limited to the crime of aggression. But then I started to have second thoughts based on the reason why. And then I heard that we have already the crime of aggression being defined, and that this definition is quite well built when it comes to this interplay between the collective aspect concerning the act of the state and this individual criminal responsibilities of this individual aspect, and it's already included in the Rome Statute. And bearing this in mind, when we ask why we need this special tribunal, the reason is simple. We have the definition in the Rome Statute, but we can't use it. Why? Because we are unable to trigger the jurisdiction. And in this perspective, we need to have in mind that we can't deny that the reason we think about establishing the special tribunal is that we are well aware that although we already have the definition, we are unable to use it in practice by the authority who was designed to do that when this definition was agreed. So it's one problem for me that we will always have some problems that we just couldn't trigger the jurisdiction. We didn't have this temporal aspect in this context, so that we created a separate judicial authority based on actually the same definition. And the more the potential statute would be similar to the Rome Statute, the more striking will be the objections that we just switch the emphasis and transferred the powers to the separate authority, because some guarantees that we already had in the Rome Statute were aimed to do that. It's just one point that will happen, and I'm afraid that it's not only the problem that is seen by somebody who will question the legitimacy of the special tribunal on whatever grounds, but behind that there are also very strong normative reasons. and normative doubts that we need to deal with. And it's my first point. And the second one is somewhat connected with some objections that were directed towards the ICC and its practice, especially some problems with its efficiency, the problems with the way this authority acts, and this constant concern that we will not be able to reach the high-level leaders by means of the ICC. And in this perspective, I would just like to briefly mention, I spent the last 4 years by analyzing only this subjective aspect of participation in crime, and I was looking how this practice was evolving for years. And it turns out that the current practice of the ICC is, first of all, not afraid of stating that the head of state is able to be brought to justice, even, and we are focused on this specific concept of indirect perpetration, which is based on the control over the state and over its structures. And when we look carefully at the most recent case law of the ICC, we see that they are no longer focused on the foreseeability of the atrocities being committed or the actual knowledge about concrete attacks, but on whether the person in charge knew about the structure, how it works, and was aware of the ability to control this structure. And in this perspective, when we apply it, and we already have some elements in al-Bashir cases, the first one which dealt with the responsibility of head of state, though only at the level of arrest warrant. But we have some paths and some strong indicatives that if the ICC was to deal only with war crimes, crimes against humanity, living inside the crime of aggression, the authority itself could reach the highest state leaders. And why is this aspect important? It's particularly important when we take in mind the aspect of reparations that has already been mentioned, because when we reach this level of responsibility, we already have the effective instrument used to reparation and compensation, and also we have some very specific procedural instrument that, for instance, gave special treatment for the witnesses who decide to witness against their leaders. They may be free from their responsibility. It's a very specific instrument which enables to use these low military leaders and civil participants on the other part of the conflict, just to persuade them to witness against their leaders. And such testimonies might be of the utmost importance when we think about this pragmatic aspect of criminal justice when it comes to the link with the crimes already committed and the one that are still being committed on the territory of Ukraine. Thank you.
Thank you, Alexandra. And Professor Zavrukha.
Thank you. Thank you. I would like to bring our discussion a little bit down to the ground and just ask two questions. First, very basic. Do we believe that Russia committed a crime of aggression? And second question is, do Russian individuals who are in position effectively to exercise control over or to direct the political or military action of Russia shall be liable for a crime of aggression? If we say yes to those two questions, then the next question, what is the best option? And I understand the concerns that were expressed here. They are all real concerns, super legitimate concerns. And but the question is that we need to move on. In the ideal world, of course, in the ideal world, the act of aggression wouldn't happen. But ideally, the ICC would try the case. That would be ideal. But again, the question why ICC cannot do so. Thank you for all your remarks. And I think we just can't escape the conversation on bringing about criminal justice without dealing with the framework of international global order. We just have to face, the question is not whether we need the tribunal, the question is when and how. Because all the purposes of criminal law are still the same: deterrence, prevention, responsibility, and they will all work. And I did bring to the point that for historical record, it's, of course, we see streamed on live the events in Ukraine, but we all know that we are lawyers, we know the power of interpretation. We don't know how the events will be interpreted in 20 years. And actually, we can see how Ambassador Nibenze in the Security Council interprets the events that are streaming online. What is their interpretation? And Russian allies believe that. They believe that the scenes in Bucha were just falsely insinuated, and the Ukrainians are responsible for that. So that's why we need the court. We need justice. We just need the court for the purpose of the court to bring legitimate decision. I do again, I'm a big supporter of the ICC, and I do agree that this is this can potentially weakness the position of the ICC, but on the other hand, I think it's basically up to us and up to lawyers not to do that, to keep the ICC, to find the form of cooperation, collaboration, and etc. Because in the future, the ICC should be the court. It should be one court, one crime, precisely defined, and very narrowly defined, only for Ukrainian case and only for the crime of aggression of Russia against Ukraine. Thank you.
Thank you so much. And I have problems with what you said, you know, because I started to think, if being a judge, I'm a judge of the Supreme Court in Poland as well, in the panel chamber, could I think nowadays about the presumption of innocence of Putin, for example? And how will it work in the court after all we have heard and saw? Yes, you know, I'm just asking myself. That will be also a question to Ambassador Korynevych. Yes, seeing all these obstacles with creating of a typical court. Yes, and all these problems you mentioned with legitimacy, how to create it. And knowing that this special court tribunal, I'm a fan of any kind of rational justice being given by someone with authority, yes, not politicians, not general ensemble or anything like that, a politician power body, but of someone who has an independent authority to say what the truth is, what the guilt is, and perhaps also announcing the punishment. You know, thinking of that, I'm realizing that we deal with the reality that would never have happened. So we have to create a justice during the war that might end with such a final that Putin and all his generals will be captured, maybe by Russian themselves, and then transported somewhere, I don't know where, to Kiev or maybe to Warsaw or Berlin or whatever place, yes, that might have happened. But the reality is what Professor Waters says, that it will be the court in the time of war and working in the time of war, yes. And should we, just to obtain in effective way the justice, wouldn't it be better perhaps to start to think a little bit out of the box? Because if we go the typical way to create an international court, as for the former Yugoslavia, it is not a pattern. Because at the very beginning, we will find this reality. Putin is still the president of this country, yes? You know, I was just asking myself at the very beginning of the war, we started to make the seminaries and the discussions. And I was just wondering why the Polish prosecutor couldn't institute an investigation in Poland against Putin and all of his generals and some propaganda men, because we have the Polish crime of aggression. And it covers also, it covered also and covers also the war in Ukraine. But why it didn't happen? And the first question and the first answer was, according to the Polish procedure, to the rule of law, I have to get the criminal personally to present him the allegation. And unless I can't make it not in person, in absentia, yes, because it wouldn't be the rule of law. So we have to discover something out of the box. The ICC have to get the man, and to be this man, the bad guy, should be brought to Hague to be punished and to be persecuted. So shall we wait until the war is over and then to prosecute? Because then we will have the chance to get Putin and all the other men. You know, even in that simple thing, we will get to the limit of the rule of law, of the normal and typical way how the courts are working. Maybe Ambassador Korynevych will have some solution for us. For me, as a Polish judge, I would really love to judge all this person, but
yeah, thank you for this question and several others which were made by our colleagues. Of course, a very interesting discussion, and of course, I'm not in a position to give ideal answers, as nobody is, I'm sure. If there was ideal answer, ideal solution, it would have already been implemented. I'm sure of that. So if I may just, I think that interesting things, both from academic perspective and from practice perspective. I will start with practice one, so if you don't mind. So I also do personally believe that doing something through United Nations General Assembly might be the most legitimate way, of course, because this is legitimacy, worldwide inclusion, engagement. But here there are practical issues, which I'm sure a lot of people here in this auditorium understand. So first of all, we need to have support from P3, all of them. Because whenever you need and you want to have something done in UNGA, you need to have backing of P3. Otherwise, your proposal might not get the things which you want. And then we need to decide whether we go first to the Security Council to get a Russian veto. And then the other days, the next day, literally go to GA. So we need to be so prepared with all the solutions, with all the packages of relevant documents, so that immediately after Russian veto, go to the GA. And for that, you need to have all the background prepared and supported. And here is the other issue. Veto is when there are 9 votes in favor. When there are less than 9 votes in favor, it's not a veto. And it might be a tricky thing, the number of votes in Security Council. I'm sure you know what I mean. I'm not so afraid about the number of votes, which I think several of our distinguished colleagues talked about. Because, I mean, when I worked in New York for some time, in November and December with missions there, I think it's quite obvious that there are iconic resolutions on UN Charter issues like non-recognition of so-called referendums or territorial integrity. They get 141, 143. But there are other special issues like reparations, for instance. I'm happy with the result of 94. A lot of people in Kiev are happy, and in New York, a lot of missions are happy because they thought that it might be something like 80 plus. Because this issue is not iconic UN Charter issue. And this is a sensitive and strict and special issue. So these are just my suggestions on this point on going to the GA, but I do also share the view that this is the most legitimate solution, it looks like. I think that concerning domestic courts, first of all, in Ukraine, we do have in absentia. So we do try people in absentia, and it's okay. I mean, I'm not a Ukrainian national criminal lawyer, but our courts do that in absentia. But what do I think in relation to domestic courts is that for the crime of aggression, this is not enough. For two reasons, at least from my point of view. First of all, because of course Ukraine does have jurisdiction to try Russians for the crime of aggression, but on the because of territoriality, because of this principle. But on the other hand, it may be sounded in such a way that this is a victim trial which may be not so legitimate and credible or whatever. So even if it is domestic or hybrid something, it needs to have a strong international element. International judges, international prosecutors, for it to be seen that it is not only Ukraine's suggestion that these are criminals who committed the crime of aggression. And I think that this court is important because also some of the colleagues mentioned that we already know that this is aggression. Yes, but we cannot try Russian Federation as a state for that act of aggression whenever they sit on the Security Council. But what we can do is we can try individuals for the relevant crime of aggression. And I think that we may use this understanding that aggression has this twofold approach as an act of state and individual crime of leadership. I think we need to do that. I don't see problems, really very big problems with ex post facto jurisdiction because actually we have a General Assembly's resolution of March with recognition of aggression. And since March, the war is ongoing. And the same goes for why do we do this now? First of all, we don't know when this tribunal might be established. If it was for Ukraine, it would have been established yesterday. But we cannot do that ourselves alone. I think that it's like we are in 1942 now in London, when London Declaration was adopted, without understanding pretty much what will be next. But the Allies agreed to try war criminals in St. James Declaration. So I think we don't know what will happen in some time, but I think that we need to get ready now. And I think that, you know, for us lawyers, we might find immediately 1,000 arguments why not to do anything. And this is true. I think it's not time for such kind of excuses now. About weakening of the ICC, I think an interesting point is that the idea of the Special Tribunal for the crime of aggression is supported by many people who very much support ICC. And you know these people, you know the names of this academics, experts. Why? Because they do believe that the establishment of a special tribunal will cause discussions inside the ICC and ASP, Assembly of States Parties, for the strengthening of the jurisdiction of the crime of aggression. And if nothing will be done for crime of aggression against Ukraine, then nothing will be there triggered in the Assembly of States Parties. And I think the essay, which I mentioned to you, published yesterday in Frankfurter Allgemeine Zeitung, is exactly about this issue, that these tracks can go in parallel, and special tribunal can actually support the International Criminal Court. And of course, I think the most important question from Professor Sharvan is, why do we need this court? Why Ukraine needs this court? I think for us, the answer is obvious. We need to stop impunity of Russian leadership. we need to get them to responsibility. As we see from 2014, there are no other ways to bring them to responsibility. 8 years already, 9 years is on. All the possible tools are not enough to get those. It's not only Putin, it's Bortnikov, Patrushev. Whether it is so easy to establish the linkage of Patrushev's or Bortnikov's complicity and participation in war crime, this should be done. They are war criminals. But for crime of aggression, it's so much easier. And this is their crime because they planned this all. So I think that talking about these issues, I'm sure that we will do what we do. We hope that we can succeed in this. Thank you.
May I ask you, Professor Ambassador Korynevych, one more thing, because you said that in Ukraine it is possible to judge someone in absentia and to persecute even in absentia, maybe in some other jurisdiction. You remember the story of Pinochet and one Spanish judge who wanted to persecute him. Why not to repeat this story once again? Why not to use the jurisdiction of some other country? Aggression as a crime is persecuted all over the world. In each country, even in Russia itself, there is a crime of aggression, literally in the criminal code. So, you know, I'm coming back to the question Olena just put to us. Why do we need? So I understand the Ukrainian point of view. It might not be the national Ukrainian court because in the time of the war, it is really very difficult to follow the presumption of innocence of someone who is the aggressor. Yes, why not to use some other country? Let it be Spain. Why not? Because the idea of the general jurisdiction, universal jurisdiction in the Spanish law is very broad.
Yeah, sure. Well, a very good question. If I may just briefly, I mean, again, I'm not a national criminal lawyer, so, but the question is not about this, of course. I think that why we cannot do that is mostly because of the issues of immunities. So at least of Troika, head of state, head of government, and Minister of Foreign Affairs.
But all the others, all the generals you mentioned, all the
number 4, not only generals, but number 4, number 5, number 6.
Yeah, why not? So
well,
why
national states can do that. National
but why
states
not
can
to
do that.
push the national states in this direction?
Because still, when we have a solution from only one state, with all due respect to each and every particular state and its jurisdiction, we need to give response which will include international action, because this is blatant and flagrant violation of international law. Whether a response from only one national jurisdiction of state A will be enough to cover the blatant and flagrant violation of international law. And there is also, I think, political issue. Well, you know, aggression, yes, a lot of states do have this article in criminal codes, but whether they will do this, politically speaking,
you know, because you know what I'm thinking about, because the idea of the crime of aggression and the agreement on that was that it will be implemented in national law. Why? Because we thought, and it was also the idea of all the treaties, just creating this general criminalization of specific crimes, that in that way we force the national jurisdiction to persecute this kind of crimes, not avoiding them, not just showing or pointing out the ICC who might be responsible for that. You know, when we say that because of the political reason, we would rather avoid the national jurisdiction to deal with this kind of crime, we undermines the treaties, because that's why we signed the treaties, to force the national jurisdiction to follow this, to persecute these crimes. Otherwise, we say it is a fiction, just to sign the treaty, that it is a crime that should be globally recognized as a crime also in the national jurisdiction order, yes, in the national jurisdiction or criminal system. And that's what you say. undermines this idea.
I mean, we do have in Ukraine criminal investigations now concerning the crime of aggression done by Ukrainian prosecutors, but not in relation to highest at Troika for sure.
Yeah, that's
So
true. I'm
that
not
is
talking
why,
about
yeah.
the immunity because it's a separate problem. I'm talking about this middle figure who are totally covered by national criminal codes everywhere.
Well, I may not be in a position to answer your question. I may be in a
Ask
position.
some other panelists to answer.
Yeah, I may be in a position, and I think I tried to explain why it's a matter of concern if only Ukraine does this alone. But
yeah, that's true. That is for me. It is clear. Yes, but why they are not the other country? You know, especially in the European Union, if there is an judicial decision given in one country, it is recognized by all of them, of the European member countries. So why not follow this path? Why not follow this?
Probably there is no will for that. Nobody wants to do that. Or we have to wait a little bit. The idea is absolutely clear. I agree with that. Just to find a way to start the prosecutions in each country all over the world, or in some of them. It will be just enough to condemn the aggression, to show that it's something against the law, try to find a right way to doing justice according the model of rule of law. It's very easy. But I really don't know why we didn't start that one.
Yeah, I say it because we have this principle not in absentia. It is not possible.
Sorry.
Olga,
yes,
Olena,
go on.
Go on.
Yeah, if I may, I think if I can share, that would be the best scenario. And since crime of aggression is almost in every criminal code or penal code, Ukraine is already investigating. Poland should investigate. But then when we have multiple countries investigating maybe the same people, the question is of efficiency and what will happen next. So here is another argument for the special tribunal. If we have all this investigation, why not have one court with recognition and tools and resources to try and sentence that person? Because if we have Poland will start trial, then Lithuania will start trial, how we will share that one defendant in that trial? So for me, it's one of the ways, but the question I have as to this procedure, why not domestic court, is efficiency of that process and then recognition. Will each and every country recognize the verdict issued by particular domestic court? Will it find a political background in that and then grant asylum and not extradite or give away that person?
Yeah,
so that's the issue.
Just one more thing, and according to that problem, we really don't have a possibility to investigate someone in absentia, but we can start the procedure from the very beginning. We can show that it's something interesting for us, when it's against the law, we should obey. And that way we can demonstrate, we condemn that, and we try to do something to find a way to make justice against all the perpetrators. Taking that kind of thinking, if we have a lot of decisions just to start the prosecutions in all the European members country without any possibility to go further because of this obstacle, we couldn't do that in absentia. But anyway, it will be kind of showing the will. We agree generally with a problem which is connected with the crime of aggressions, and we would like to do it on the formal way, everything possible to find a way to prosecute the perpetrators. If we start from that point, probably will be a good argument to try to or establish a special court or to change the rules if we are thinking about the ICC, which is most likely for me. But talking about the general condemnation, we have 1,000 of possibility to do that on the law in each country, almost all over the world.
Now,
So
if I may just,
yeah.
If I may just, that is why, apart from the special tribunal, we are now working with our European colleagues in order to get the thing which we call colloquially IPO, Interim Prosecutor's Office, which I'm sure you're aware of is like Ukrainian prosecutors working together with European prosecutors. So secondment of European prosecutors on this procedural management of the investigation of the crime of aggression. And the result of that investigation may be used, I mean, in different jurisdictions. And I think that it is important because, again, it's not going to be done only by Ukrainian prosecutors, but with participation from EU, with participation from seconded international prosecutors. So this is something what I think is getting support, at least at EU level, and I hope that some tangible results may be visible in this respect soon. I hope.
Yeah.
If I may question to Professor Waters and maybe Professor Watson, because when Professor Watson was speaking first, he mentioned Nuremberg trial and the question he asked his students. And I personally share some reservation with respect to waiting until the war is over and hopefully Ukraine will win, because that trial for me would be questionable, and validity of that trial will be questionable because it's stronger, punishes the weaker part, or winner is already a winner, and then we need just a rubber stamp to further punish the loser. So I believe that the time is now, and I was wondering what you think based on your research of prior tribunals and mostly by winners.
I don't know who first. Professor Geoff Watson, maybe you can comment.
Okay, real briefly. I raise ex post facto, even though I acknowledge that you can make arguments that this would not be an ex post facto prosecution. I get that. You could say, oh, well, the crime of aggression exists in state municipal law, and it's embodied, at least to some extent, in the ICC and the Rome Statute of the ICC. To me, it's just more of a matter of public consumption and perception that people will see, gee, we set up a court after the fact and we're prosecuting somebody for a crime after the fact. That just, if my students' reaction is any, and my students are law students, they have a certain level of discomfort, then how will non-lawyers react? So that's my hesitate. That's one of the sources of my hesitation about this. And there are plenty of other crimes that Vladimir Putin is guilty of. He's guilty of war crimes. He's guilty of crimes against humanity and probably guilty of genocide. Those things, I want him prosecuted for those things by the ICC. That's what I want to happen. I don't steadfastly oppose a new court. Personally, I'd be okay with it. I worry though how the world, how the general public, how non-lawyers. I worry that it would undercut the bringing Putin and his cronies to justice. Whereas there'd be no doubt about the legitimacy of prosecuting him for bombing civilians, for targeting civilian infrastructure, for apparently for waging a war of genocide. Those things, people would be, I think, on board with prosecution through the ICC of those things. We already have a court that can do that. That's what I want to see happen.
Mm-hmm. Tim, would you like to comment?
Sure, it's a good question, and I was thinking about that from the comments before, so I'm glad you asked it. And maybe there's two things to say, sort of tying in Professor Watson's earlier points. I'm pretty skeptical about the project, although I'm not an opponent to it. I'm skeptical about the usefulness of this project. I don't mean this one, I mean more generally. But on this question, I'm a bit more optimistic. I'm with those who don't see ex post facto as a particular problem. I understand Professor Watson's point, and I agree that we solve this doctrinally by declaring that creating a new court is something separate from creating jurisdiction more generally. I think it's true that the layperson might say, well, what does that mean? It does sound like you're making the court afterwards, but I'm a lawyer enough to be content with that. I get the idea. I do think it's worth noting, since it's on the table, there's some ironies in this that Professor Watson alluded to. You know, Nuremberg is an ex post facto application, and after it goes through its sort of mandatory proofs, it openly just says so, right? Pointing out that there's no principle restraining us. And the irony, of course, is you look at cases at the ICTY and ICC, and I love pointing out to my students, those cases cite Nuremberg for the principle that international law shall not be ex post facto. Just complete, I mean, like objectively inaccurate reading of it, but that's just another example of this thesis of assertion. We say it now, don't go back and read the original text, which clearly says the opposite. But that's what we've moved to. And it does mean today, I see no doctrinal issue with this being ex post facto. We're on notice about this ever since just after Nuremberg, let's say. I think we can't talk about that, though, without noting the other, which is mostly missed. People focus on the ex post facto and victor's justice part of Nuremberg. It's worth noting, it's not quite the same here, but in terms of thinking about this, there's obviously another shaping of the jurisdiction of aggression at Nuremberg that's actually vastly more important than the ex post facto claim, and that's the limiting of it to one of the two countries that invaded Poland in the month of September, right? That's the one that indicates to us that this wasn't really about a system of law, but about the shaping of one set of actors' priorities. I mean, I think no one can credibly read Nuremberg as actually being about its rhetoric if you notice the fact that it's shaped to only prosecute one side for an effectively identical crime. What is it, 2 weeks later? Okay, and still the land has never been returned. Okay, I think Poles know this quite well. To your particular point, though, Ms. Sharvan, it's an excellent one. I do think the problem is that this is bad either way. You're right. If you wait for victory, the accusation that this is victor's justice is inevitable, as is the defense that all justice is consequent to some assertion of power, even domestically. You can't put people in jail unless you capture them. So that's the defense against it, but it's going to be faced with that charge. And yet, to say, therefore, it's better now, I mean, the idea of doing trials during wartime, the bias is irreducible and unavoidable. I think this is Professor Cardis's point earlier, I think, about we want courts to be non-political. We always say that, we believe it. And I think it's just not credible to think that a wartime court is going to be that and be seen as that. I think that unfortunately means that you don't have a good option. Frankly, I go the other direction. The least bad one is after the fact, because you can deal with the claims of it that it's victor's justice. There are good answers, and after all, you're the victor. So, you do the same things we did with Nuremberg. I'm less concerned about that than the fact that trials during the war will be clearly and plausibly vulnerable to those charges. And after all, you don't know where it's going. I mean, it's pretty embarrassing to produce trials and then not only not get the people, but actually lose. And this is one reason why you don't do this during the wars. This happened in the First War, even in the Second. In the First World War, there's actually open, direct agreements between the states to not engage in these kinds of punishments until after the war. It's partly a kind of reciprocal leveling down, but it's also a pragmatic calculation. Well, let's wait and see what happens. And we are nowhere near clarity on the end of this war. So I think it's just totally ill-advised to imagine doing anything now other than standing up the preparations in case it goes the way we might like. But that means you do it after the war. And then you fight the issue of victor's justice, which you can win on.
Thank you so much. Some other intervention or comments? Professor Wortham left us, I think, Leah.
Yeah, she had to leave a bit. No.
Oh, I see her icon, but I don't know if she's with us. Maybe not.
I'm still here, but I'm just walking out the door, and I really appreciate having been invited. And but I don't need to say anything substantively. Thanks so much.
Thank you, Leah, so much. Thank you. If there are no any comments and intervention, I would like to thank you, thank all of the panelists, our guests, and all participants very much. It is not the last meeting. I wouldn't even like to make conclusion on what has been said, because these are, I know there are some practical reasons we should work on this idea, and even not being a lawyer, we might be the fan of the idea of this kind of court. As a lawyer, we are also, it is our competence and task trying to solve problems, see the obstacles and the dangers that might be then realized in the future, and somehow trying to neutralize them. This skepticism, as I see in our discussion, is not the skepticism to the idea of justice, but rather the reflection on how to realize is the most effective way. And I also share the idea that it is not only the problem of Ukraine, of Ukrainian victims. We are, in a way, victims of this war as not only the universal community, but human beings, yes. Personally, I'm all the time thinking that it is really a curious and ununderstandable reality that one of the most dangerous crime in our Polish criminal law is the crime of aggression. It is at the very beginning of the criminal code, and it is also in many other countries. And when we're faced with the aggression, we can't use this weapon that we created, yes. It is not optimistic, but something that needs to be reflected on and worked on. So I think that you will hear from us in several months, and I hope that Ambassador Korynevych can feed us with some very concrete ideas that has been realized, not only planned but realized, and we can talk not about the legitimization of this institution, of this court, but maybe practical problem with the procedure, with the judges, and some other issues. Thank you once again so much for your participation, and I hope we'll see in the future. And we hope that this year will finish also with the peace and the victory. Thank you so much.
Thank you.
Thank you.
Olga, Olena, bardzo Ci dziękuję za pomoc w organizacji. Thank you, Olena, so much with the help in organization of this seminar. It was really marvelous.
Thanks for hosting. It was great. Right, Professor Watson, Zavrukha, thanks.
Thanks so much
for your time. Everyone is now busy, but it's great that you were able to join.
Yeah, that you joined us. Thank you.
Slava Ukraini.
That's great.
Thank you. Dziękuję bardzo. Do widzenia.
Dziękujemy bardzo, pani profesor. Bardzo dziękujemy. Piotrze, ja zadzwonię do ciebie, wiesz?
Skończysz i zadzwonimy, dobra.
Dobra.
Ja się rozłączę, Władek. Zatem do usłyszenia.
Do usłyszenia.
Tak,
Ja was